Welcome to our second presentation on religious discrimination. In this presentation, we're going to talk about the prima facie case and the duty to reasonably accommodate. Let's begin. Okay, so we've talked about the prima facie case in several different contexts, in race discrimination cases, in national origin discrimination cases, in sex discrimination cases. It's a similar equation that we have here for religious discrimination, but it's a little bit different because of the reasonable accommodation aspect to religious discrimination cases. So the first one establishes that the person is a member of a protected category. And in this case, this means that the person has a sincere, not severe, I apologize, a sincere religious belief that conflicts with an employment requirement. So this is getting at the fact that this person, this is similar to this person needs to prove that this person has a particular gender or a particular race or particular national origin. Then we have that the person informed the employer of the conflict. Now, usually you don't have to inform the employer of your race or your national origin or your sex. Usually that's pretty self-evident. But obviously for religion, it may not be evident what a person's religion is, and it certainly may not be evident that there's a conflict between a particular workplace practice and the employee's religious beliefs. And then finally, there has to be some kind of adverse job action as a result of after the employer knows about the conflict. So either the employee was discharged or disciplined or was denied a reasonable accommodation or was not hired. So this is the negative impact of this particular situation. So once the employee is able to prove all three of these elements, and usually there isn't a problem with that. Usually that's a pretty clear situation, as is the case with all the other prima facie cases that we've talked about. It's pretty rare that the employee is not able to make the prima facie case. Well, then, just like in the past, we've done kind of the ping pong event. The plaintiff proves the prima facie case. Now the ball is in the defendant's court. And the defendant now has to prove that either it offered a reasonable accommodation that was rejected or that was deemed to be unsatisfactory by the employee, or there was no reasonable accommodation that it could have offered that would not also have been an undue hardship. And so that the ball is now then in the defendant's court. Let's look at some fact scenarios. You'll see in this module we do lots and lots of fact scenarios. And that's because these cases are incredibly fact intensive. And so I think the easiest way to get a feeling as to where the line is, what's lawful, what's unlawful, what the requirements are that the employer must satisfy, is to go through lots of examples. So in this particular case, the employees have asked to have an informal vote to see which radio station should play over the public address system in the warehouse. They do have the vote, and a Christian music station was selected. But some employees in the facility aren't of the Christian faith, and they complain, even though there was this election. They happen to lose, and they decide that they don't really want to hear the Christian music at work. And so then the management decides to stop playing the Christian music, and it allows the employees to wear headsets or have small radios in their workplace so that each person can choose the music that he or she wants to listen to. So Bob is an employee at the facility. He's a Christian. He's disappointed that the public announcement system is no longer playing the Christian music, and he then files a charge with the EOC alleging a violation of Title VII. Under these circumstances, there is no adverse employment action. I would say not allowing Christian music to be played would not be considered sufficiently central to the work situation that it would be an adverse employment action. Nor does it seem that it is required of Bob by his religion that he listen to Christian music throughout his workday. In any event, it sounds like he's still going to have the opportunity to do so by either wearing headsets or having a small radio in his workstation. It may not be ideal for him, it may be a less good fit for him than the previous solution of having on the public address system. But it's not necessary that the employer do exactly what Bob wants. It's just necessary that the employer reasonably accommodate Bob's religious beliefs. Now, let's imagine we go back to the original scenario where there's going to be a vote. Well, let's say that the Christian music station had not gotten the most votes, and instead it had been a heavy metal station. And then at that point, Bob might have complained, saying, "Well, I don't care for the lyrics or the style of music. It is inconsistent with my religious beliefs." At that point, there could have been lots of different solutions that could be picked. Certainly, the employer might decide to turn off that music, maybe not have any music at all, maybe have music or classical music, or perhaps a news station that isn't controversial. Um, Perhaps they would tell Bob that he could wear headphones, or earplugs so that he wouldn't have to listen to the music. Or perhaps there would be a way to adjust the public address system so that it wasn't as noticeable in his area. Those would be solutions that might address Bob's problem if the facts had played out a little differently. So, if in the workplace, employees are allowed to use space for secular reasons that are not work related, then it is a good idea for the employer also to allow religious groups to meet in those areas. Now, this doesn't mean that the employer has to subsidize the religious group, so there is no need to, offer free drinks or things along those lines. But if it's an unoccupied conference room, say over lunch, and on Mondays the knitting group meets, and on Tuesday the bridge group meets, and nobody's using it on Wednesday, and the mosque reading group, the Quran reading group would like to meet to discuss scripture from their faith, then the employer would be wise to allow that group to meet and use that facility. Um, uh, so that would be a smart idea. It'd be difficult to argue, well, we don't. If you allow the crochet club to do it, why wouldn't you allow the religious group to do so as well? So now we're going to switch gears and talk about what counts as a reasonable accommodation. We've already kind of been talking about that already, certainly with the radio situation and with the conference room usage. Those are reasonable accommodation situations. So, just to be a reminder here, employees have the duty to inform the employer about the need for a reasonable accommodation. Employers are not required to read people's minds and know what's going on. The employee needs to go to the employer and say, what's happening in the workplace, or what's about to start happening, isn't a good fit for my religious beliefs. Until the employee has that conversation, the employer has no duty to reasonably accommodate something. Uh, Once the employee brings it to the attention, the employee shouldn't be cross-examined or theologically challenged. It's not important that the employer understand or sympathize or think that the belief of the employee is logical or reasonable or consistent or scripturally sound or any of those types of concepts. The employer shouldn't browbeat or pressure the employee to share more than is necessary so that the employer is in a position to reasonably accommodate those beliefs. This a process of reasonable accommodation is a give and take. Both sides need to participate in the conversation. And while the employee does not need to compromise his or her religious beliefs, there may be other aspects that need to be compromised. For example, the employee may need to give up some income because the employee may need to be moved to a position in which he or she is going to be less likely to get overtime, or maybe less likely, or maybe being paid at a lower rate of pay. Um, the person doesn't have to compromise his or her religious beliefs, but he or she may have to accept a job that is less desirable in some sense, maybe a different shift, maybe working different hours. And so there needs to be a give and take. A lot of times in these situations, there is a room for a significant amount of creativity. If both parties kind of step out of boxes and if they're open to brainstorming creative and different solutions, sometimes a solution can be reached that is mutually advantageous for the individuals involved. Most of the time when these types of conflicts arise, they're going to be centered on work schedule issues. I can't work at this time because of this holy day or because of my Sabbath, or I can't work at this particular time because I need to be praying. That's the single most common example that we see of religious accommodation. So it's good to have some ideas about how to approach those for your employer to kind of have in its back pocket, so to speak, so that when these issues come up, and they likely will come up at some point if the employer has very many employees at all, so you can have a plan. Okay, these are the things that are oftentimes going to help us work through that problem. Okay, so let's look at what that duty to accommodate looks like. Well, one is it attaches to whatever that conflict between the religion and the work practice is. We don't really worry about when the conflict arises. Many times, an employee will come to work for an employer and not mention the fact that he or she has a religious problem working on Saturdays or working on Sundays or working uh, during a high holy period in their faith. And then they come to work and they've started, and a few weeks later they're saying, oh, yeah, I can't work that day. Now, the employer may say, why didn't you tell me that? I wouldn't have hired you if I had known. And that's probably the reason they didn't tell you that point. It's not important that they are now raising it. The question is, now we know about it, and now we have to address it. Um, I suppose in some cases that might raise an issue about sincerity, but again, for the most part, that's not a very fruitful issue to look into. After hire conversions, and not just conversions, but just a person renewing his or her commitment to his or her faith can be a legitimate process. And it's very hard for an employer to prove that this person hasn't renewed his or her faith or converted. So once the employer knows about the conflict, the employer is on duty to act. Now, sometimes the employee will give us lots of notice. Hey, in a month from now, I've got this holy day coming up. I'm going to need the time off. And so you have some time to work with. On the other hand, it could be, hey, today's Thursday. I'm going to need Saturday off. And so you may have relatively little time to work on it. It does, obviously one question to ask the employee is, how come you didn't mention this on Monday? And their answer may be, well, I've been praying about it, and I heard a message from Scripture or from my prayers that I ought to proceed in this way at this time. So it's going to be hard for the employer to say, oh, I don't believe you. I mean, you can say it, but it's not a smart strategy. And so the best course of action is to act as quickly as possible to work through a way to resolve the issue. So here are some examples of things that might be necessary to accommodate. Worship rituals, for example, in some faiths there may need to be a particular requirement for prayers at a certain time or certain actions that need to be taken. They may need to point in a certain direction or perform certain rituals at certain times. They may feel that they need to proselytize at work, that they have a religious obligation to persuade other people to share their particular theological perspective. And it might be generally to convert to their faith. It could be to convert to a particular issue. For example, perhaps to a pro-life perspective or to another uh, religiously based idea. Now, obviously, some people proselytize about a secular issue, such as um, uh, they want everyone to cheer for the Cowboys, or they want everybody to vote for candidate X. Those may or may not be good ideas, but they aren't religious in nature. So a pro-life perspective could just be political. A person happens to have that political viewpoint, or that particular viewpoint also could be religious. So when somebody is espousing a political or philosophical perspective, be aware that it's also possible that it could have some theological or religious significance as well. In some religions, people have certain requirements for how they dress or how they groom themselves. They may be required to dress especially modestly. They may be required to wear certain colors, to cover their hair, to wear certain pieces of jewelry. Um, they may be required to not cut their hair, to not shave their beard, or they may be required to have a beard. Um, you know, so there can be lots of different grooming requirements. Now, you shouldn't assume that because a person happens to have a beard, for example, that there's a religious component to it. That may just be a preference that that person has. But when the person brings it to your attention that it has a religious significance for him or her, then that's when you have to start thinking if that attire is outside of dress code or if that grooming practice is outside of the dress code. Is it possible to accommodate it? Is there some alternative way of working through that issue? Sometimes organizations have diversity programs where people get together, oftentimes with a facilitator or a trainer, and discuss the importance of supporting and acknowledging and respecting the differences within a workforce and honoring those differences. When I was in corporate America, I participated in several of those, both as a participant and sometimes as a leader in those types of endeavors. And sometimes those presentations and workshops were very inspiring and positive, and sometimes they weren't so inspiring and positive. And sometimes people in those presentations have strong disagreements or policy issues, lifestyle issues, lots of different issues can come up. And so that can be a moment in an organization wherein somebody says something. I'll give you an example. They may say, well, my religious beliefs are such that I think that a same-sex sexual behavior is sinful. And so I can't honor or respect that because I believe that's not a good choice. So if they are told, well, you can't have that view because our policy here is that that should be a respected lifestyle that we should acknowledge and respect, and you saying you can't respect it, well then, that's not consistent with working here. Well, then the issue is, well, if it's not religious based, if that just happens to be that person's philosophical or political perspective, then yes, the employer can say, okay, we don't need your services anymore. But when it's religious, then it becomes a more subtle issue. And in a situation like that, usually what you can say is, well, maybe we're having a disagreement about words, and maybe we can think about different ways of saying that. For example, if you had a coworker who was in a same-sex romantic relationship, you would be able to talk with him or her in a civil tone of voice, right? And probably the person would say yes. And you could talk about work-related matters, correct? Probably so. And you wouldn't say insulting things to their face or behind their back, would you? No, I wouldn't. And so there might be a way of working through uh, a way that allows the one person to continue to be true to his or her religious perspective on this issue, and yet at the same time follow the company philosophy generally about same-sex attracted individuals. So again, it can be a careful balance, a careful walk through that process so that the goals of the company can be respected as well as um, the rights to express themselves as a religious person. And of course, in a diversity situation, one thing to keep in mind is if you want diversity, you're likely to want diversity of religious thought as well and ideology. And so the inclusion of this person actually increases the diversity doesn't decrease the diversity of perspectives in your workplace. So again, these are difficult issues to talk about, sensitive issues to talk about, but many times they can be resolved in a way that is that's going to work for everyone. So, if the employer is confronting this type of situation, again, one thing to keep in mind is it really a religious issue, or is it a philosophical issue or a political issue? If it's philosophical or political, it's probably not going to be covered by Title VII or really any employment discrimination law. There are a few states out there that might have political views be covered. And certainly, if you're talking about a public employer, political views would usually be protected. But for a private employer, we're really focusing on just the religious views. And you want to make sure that you're doing a good faith attempt at accommodating that particular faith. Now, sometimes, most of the time, this isn't an issue, but every now and again, you will find that the religion that you need to accommodate is one about which you, as the manager, may have uh, a disagreement with, or may find certain tenets offensive, or at least disagree with those tenets very strongly. Your particular reaction to the faith of this worker, though, isn't relevant to the legal obligation that your employer has to make a good faith accommodation. This protection isn't just for popular religions or religions that happen to have a point of view that is widely accepted in the larger culture. If the religion were popular, widely accepted in larger culture, you probably wouldn't need to accommodate it, right? So it's not a test to see if you agree with it. It's a test for you to make that good faith accommodation. On the other hand, the employer's duty is not infinite, and deciding when the duty has become an undue hardship can be tricky. Certainly fact intensive, but many employers will want to stop at that point. There will be other employers, though, that might be willing to go beyond that because they want to be that good employer who's concerned about the welfare of their religious employees. As I said before, it's an iterative process, meaning there's going to be a back and forth. You're probably not going to get this resolved in a single 20-minute meeting. Um, you are you're going to, maybe both parties are going to kind of talk about through the issue, put some ideas on paper, think about it, come back, try a few things. Oh, that doesn't work. Let's try something else. Oh, that does work, but we need to tweak it in this way um, to get through all of the permutations that might come up. And so that's one of the reasons it's important to jump on it as soon as the issue comes up, so that it's going to take a little while many times to resolve this. So the employer doesn't have to worry about liability if the employee is reasonably accommodated, if you have satisfied the obligation. It doesn't have to be the employee's first choice. It can be. Obviously, that's a great situation when you're able to do exactly what the employee wants. But even if you can't do what the employee wants, if you're able to satisfy the religious aspect, because many times what is bundled up in the employee's request is more than just the religious component. The employee may have other aspects, and we'll see this in several examples, where yes, there's a religious component, but there's several other things also going on. And again, the employee has to be reasonable. Um, and hopefully the employee will be acting in good faith as well. Now, the employee doesn't have the obligation to act in good faith, but it certainly makes the process a lot easier when the employee is understanding the issues that the employer faces and is trying to work through those issues with the employer. So here are some things that might be factors in deciding whether a particular accommodation qualifies as a reasonable accommodation or whether it becomes an undue hardship. One, of course, is whether the employer tried. Did the employer actually engage in this iterative process? Did the employer sit down and listen and brainstorm and propose something along those lines? So, was an effort made? Another can be the size of the workforce. in many cases, especially when an employee doesn't want to work on a particular day, it's going to mean that some other worker is going to have to work on that day. And so if there's a relatively small workforce, it may not be nearly as possible to accommodate that. And of course, the workforce may be large, but if it's a very specialized function in the workforce, and the workers in other areas aren't able to sub in for this other area where the religious employee is working, then that of course means that the actual practical workforce is much smaller. Another issue can be, the type of job. Is it a job that is you can easily train people to do? Is it a job that involves highly specialized skills? Um, is it a job that requires that the employer have a lot of trust and faith in the particular employee doing this task? And so that can be a factor. If the employer was willing to check with other employees to see if they're willing to assist with the accommodation, that's a really good fact. Many times the employer will put that obligation upon the employee, but sometimes the employee may not know enough of the workers or may not have sufficient access to the workers or may not, because he's just a peer, may not be in a position to be as persuasive to the employees. But if a supervisor is going around saying, "Hey, would you be willing to swap shifts with somebody to work on this particular date?" An employer who's willing to do that has probably gone a pretty far way down the road of reasonable accommodation. And then we talked about financial costs, and remember the key term here is de minimis. If it has any significant cost, it's going to be more than de minimis. And under the interpretation um, that we have from the Supreme Court is really the employer has to spend very little money in order to satisfy that reasonable accommodation requirement. Then we also have administrative and operational burdens that can occur when you have these types of situations. For example, if there's in this, it ends up there needs to be this very complex job sharing system, and it's confusing, and nobody's quite sure when they're supposed to show up, and those types of things. Those are the things that can potentially cause it to become burdensome, even if it only is causing a very small or no financial cost. Now, this one I would be concerned about relying upon this exclusively. You're really going to have to prove that you actually have these burdens. And that probably means you're going to have to try it out to see, because if it's just a theoretical burden, you really don't know until it actually happens. And the fact that it was a logistical train wreck the first time it happened, the first time you tried it, doesn't mean that people aren't going to figure it out and that it won't be very, very smooth by the third or fourth time that you try it. And so I encourage you not to rely exclusively on this, especially when it's in the hypothetical area. Now, if you've actually tried it for a period of time and it really just didn't work, and you have facts you can state and examples you can state, that's when this factor can become more meaningful to your analysis. So here are some examples of religious accommodations that employers ought to be aware of. One is to allow the employees to swap work shifts so that the religious conflict can be avoided. Again, you're going to want to make sure that the employees who are swapping are qualified for the job, and you may have limitations such as employees can't work more than 40 hours, so there's no overtime concerns. But if you have those limitations on it, it's hard to argue that allowing employees to swap is going to be an undue hardship. There might be some arguments. I mean, if there's a lot of tensions in the workplace between particular employees, and if you allowed people to swap so they might be paired with a person that just doesn't get along with that person, I could imagine there could be times where a voluntary swap system at least might need to be vetted or approved by the supervisor. But generally speaking, that's a pretty good approach, especially when the function that the employees have is relatively fungible. And by that I mean there aren't special, unique skills that the parties have to have. For example, um, the janitorial service. Let's say one task that a person does is to sweep the floors. Well, I would say that probably anybody with a minimal amount of training is going to be able to sweep the floors. But let's say you have a jewelry department in your store and you happen to have 10 salespeople in that department. But really, you have three that are kind of your all star salespeople, and they really drive most of the sales. They are able to pull those customers in and persuade those customers to make the buys. And so, you always want to have your best salespeople there at the heaviest, highest traffic time to maximize your sales. And so, even though all 10 of the people have the same job title and the same job responsibilities, you might really want Bob, Teresa, and Sally, your top salespeople, always to be working Friday evenings, Saturday afternoons, and Saturday evenings, for example. And so if it ends up that um, none of those three are scheduled on a particular Saturday afternoon, your store may see a significant drop in sales. So you want to make sure that if you have a swap system, that it's aware of all the different functions in that. You may want to adopt some kind of flexible work scheduling so that people are able to opt out of or indicate a preference not for working a particular work schedule. And so that, in some places it's not really necessary that you have people there all the time. In a retail store, probably is, but let's say you have some typists. Well, some typing work might be kind of urgent with a fast turnaround time, but there might also be work that can be done, um, you know, uh, at other times in the day. You may not have to have a typist there every single minute of every single day. Another approach is to allow employees to use vacation time, oftentimes called PTO time. Sometimes this time off could be paid or unpaid. That can be a smart approach, especially when we're talking about just a few times a year. Some employers provide some floating holidays. We'll see an example of that in a couple of minutes, wherein people can take off, their birthday if they want to, or Martin Luther King Day, or some other holiday that's meaningful for them. And maybe those holidays could be religious holidays. An employer could, for example, take away the Friday after Thanksgiving, or take away a vacation day, or some other holiday that the employer has, and give back that day to the employee. Some employees probably still choose to take that Friday after Thanksgiving off, but others might choose to take off, a high holy day for their faith. Permit lateral transfers and job changes when that can be helpful. We won't talk about this in detail now, but a smart strategy in many places of employment can be to have a job posting board where people can be aware of what jobs are available and they can apply for those particular jobs, be they transfers, lateral moves, promotions, even position step downs, depending upon their particular circumstances. Maybe they want to work a different shift. Maybe they want to work in a different department. It may be possible sometimes to schedule events if, for example, you have a key employee who really needs to have a particular day off because of a religious obligation. Well, you may want to look at what you had scheduled on that day. Maybe it's locked in stone, but maybe it's not. Maybe it can be moved to a week earlier or a week later. And then, of course, being flexible about dress and grooming standards when that's possible can make a lot of sense. Now, sometimes this isn't possible. There may be safety issues involved, and certainly under those circumstances, safety almost always trumps religion in this context. But when safety isn't an issue, there can sometimes be ways to adapt or modify those policies so that the purpose behind those grooming standards are maintained, even though there is some variation for the particular worker. Let's consider some more scenarios. So Mary's Jewish. She's applied for a baker's job. After she's hired, she tells the bakery that She can't work Friday night because for her, the Sabbath, her holy day, begins Friday evening. The manager says everybody has to work Friday night. And if she refuses to work Friday night, she's going to be fired. Under those circumstances, Mary does have a good claim of religious discrimination. Now, the employer might say, well, why, she was Jewish when she was hired. Why didn't she tell us then? Um, an employer is not wise to um, use that approach um, and to deny an accommodation because Mary delayed mentioning it until after she was hired. If she had told the baker about it before she was hired, or the bakery before she was hired, she probably was concerned that the bakery wouldn't hire her. You can see this particular bakery didn't attempt to accommodate, didn't even engage in a discussion about it, just said, nope, we're not doing that. And so, as we saw back here on our list of things to look at, he missed the very first item. So Mary has worked in a place for 5 years on an assembly line, and most of the people who work on the assembly line are male, unmarried males. Mary goes through a religious conversion, and she feels that her new religion prohibits her from working in close proximity to unmarried men. And so, under those circumstances, the employer should look into reasonably accommodating Mary. Perhaps it can put her in a different section of the assembly line. Perhaps it can put her in a different portion of the facility where there aren't the unmarried men. It may not be possible ultimately to accommodate Mary. Certainly, the company isn't going to fire the men or make them get married or something like that. And so it may be a problem that there is no undue hardship. I mean, there's no solution that isn't an undue hardship. But at a minimum, the company ought to uh, engage in the iterative process. And of course, when I talk about the iterative process, it needs to be documented. A very popular thing for legal professionals to say is if it didn't happen if you don't write it down. You need to keep a diary of this type of thing. If you encourage the client to keep a diary of the date, the time, who was present, and what was discussed, so that you can show a good faith effort to accommodate that employee. Aisha is a Muslim. She works in the army. She's requested to wear a khimar, which is a headscarf, with her uniform. I may be mispronouncing this. I apologize if I am. Her commander says, well, no, you can't change military uniform appearance. You have to follow that. That's specifically barred to wear religious symbols or dress while in uniform. And after Aisha is told this, she shows up to duty wearing the khimar, and she is demoted as a result of this. So Aisha files a religious discrimination claim. Well, she's not likely to win because the Army can demonstrate that it would be an undue hardship for it to veer from its uniform regulations because it wants to maintain that military cohesion within its ranks. And if some people are wearing a Star of David and others are wearing a cross and some are wearing a crescent and some are wearing this and that, it could lead to the esprit de corps of the military being diminished. And so that is not going to be a winning argument. That argument works for the Army. It doesn't work for very many other people. It probably would work for the police and the fire department. But other than those limited functions, um, in most cases, Aisha is going to be successful if she wants to wear a covering of her hair, especially when it doesn't interfere with her ability to see and be seen, and there aren't safety concerns with it. Let's consider Bob's Pizza. So Bob's Pizza requires all of its employees to take a 10-minute prayer break per shift in a special room that contains a crucifix. Mary's an employee there. She's an atheist and she doesn't pray. She complains because she thinks that this time is this time on this break was a waste of her time, and she'd like to stay in her workstation. After she complains, Bob's Pizza fires her. Under these circumstances, Bob Pizza is probably liable for religious discrimination. Now, there could be some ways that you can work around this. Um, uh, Mary could spend her 10 minutes somewhere else, maybe in her car, maybe in a private location, or perhaps Mary could be permitted to remove the crucifix and return it when she is done with her 10 minutes. Um, if Mary feels like she cannot, in good faith, handle the crucifix, uh, perhaps the manager could remove it before Mary goes in for her 10 minutes and leaves before her 10 minutes. Obviously, Mary cannot be required to pray, but she, could be part of the job responsibility to take a 10-minute break. So again, but probably the best answer for Bob's Pizza is just to say, Mary, if you don't want to pray, don't pray. Go about your business, take 10 minutes, get some fresh air, whatever. Um, so Bob's a mechanic at Anna Tire. He has to work 40 hours a week, including 2 Sundays per month. Bob tells his supervisor he worships the NFL and he can't possibly work any Sunday until after the Super Bowl. Under these circumstances, obviously, Bob's religion is not truly the NFL. It is not a sincerely held belief. And so Anna Tyer does not have to accommodate that quote unquote belief. Aditya is a devout Hindu and he's a waiter at Frisco restaurant. On a day when a banquet is held, he comes to work with a religious symbol on his forehead. And when he's confronted by this by the manager, Aditya claims that the symbol the symbol that he's using is a sign of good luck in Hinduism. And Aditya says, "Well, I told you I was Hindu when I came to work here initially." The manager still fires him. Now, I don't say this in this particular example, but in the example this case is taken from, what the symbol that Aditya, or whatever his name was, and I've made a different name here, was a swastika. The swastika we associate with Nazi Germany, but it actually is an ancient symbol which does not have an evil meaning in other cultures, but it still looks like a swastika that we associate with Nazi Germany. And so you can imagine that somebody seeing somebody with a swastika on their forehead, that would be a little disconcerting for someone. But for Aditya in this situation, it's a sign of his religious devotion. So in this case, Aditya could make that prima facie showing that this was a practice from his faith, that it conflicted with a, a company policy, and that he was fired, so he had an adverse job reaction. It would have been better for the manager to say, listen, Aditya, let's think through some ways we could do this. For example, maybe Aditya could wear the symbol somewhere other than his forehead, maybe in a part of his body that is covered, maybe on his shoulder, for example, if he wears a sleeve on his shoulder, or on his chest, when he's wearing obviously a shirt that would cover up the symbol. Or perhaps if Aditya was not comfortable doing that, perhaps he could wear a bandage over that would cover the swastika. Or perhaps for that evening, maybe Aditya could work in the kitchen and not be customer facing. So those are just some ideas that at least the manager should have talked with Aditya about. Again, that goes back to that iterative process. If you don't even engage in that, it's going to be very hard to show that you attempted to reasonably accommodate. You may not be able to reasonably accommodate, but you can at least have a discussion about it. Now you might say, well, he's in the middle, the manager's in the middle of running this event. He doesn't have time for that. Aditya kind of arrived unexpectedly wearing this symbol. And that is one of the challenges under these circumstances. You don't know what's going to happen until it happens. But that's kind of the deal about being a manager. Sometimes you have to break away and say, hey, Aditya, let's spend 5 minutes talk this through. So Salina Hospital has 20 Muslim employees in its maintenance department. So there's a significant number of workers who have requested a special place to pray in accordance with their faith. The hospital's designated a room in the basement to allow these employees to pray. Muhammad is one of these 20 Muslim employees. He actually refuses to use the room in the basement because he feels that the room degraded his religion. So instead, he uses the visitors' waiting room on the third floor to do his prayers, in spite of his supervisor telling him not to do so. Subsequently, he was fired. Um, so he would have preferred to pray in a different place. But unless he has some reason why it's degrading to pray in this room, I don't think that Muhammad's going to be very successful. If it, if he can say, well, it fails to meet a particular requirement that we have for our prayer space, then that's legitimate. But simply saying, I would prefer to be on the third floor versus the basement is not a basis to object to the accommodation. So it appears that Muhammad is here, his religious needs are being satisfied, but he has a separate issue about I don't particularly care for this location. And that personal preference aspect isn't one that the employer necessarily has to accommodate. So Mary's a deputy with the sheriff's department. Anti-abortion protesters announced that they're going to hold rallies at medical clinics where abortions are performed. So the sheriff's department decides to assign some officers to guard those clinics for public safety reasons. Mary tells the chief that she has strong religious beliefs opposing abortion and she can't in good faith guard such a clinic. Okay, so she's requesting a reasonable accommodation. This chief is smart. He says, okay, we need other police officers. You know that not every sheriff's deputy is going to be guarding. So I'm going to assign you to be doing some other tasks, and I'll send some workers who or some deputies who are comfortable with this particular duty. So that's a great example of reasonable accommodation. The chief deserves a gold star for that. During one of the rallies, though, a riot breaks out in one of the clinics, and she happens to be in the area doing other work, and she's one of the officers called to assist by dispatch. Mary refuses to respond to the emergency call, and she's fired. Under these circumstances, I'm afraid Mary is out of luck. Her job responsibility is to respond to crises like that, and her duty is to protect everyone, be they pro-life or pro-choice individuals. And it was reasonable to accommodate her risk in a non-emergency situation, a non-crisis situation, but not under the emergency call circumstances. So at this law firm, the receptionist has many jobs, but one of the jobs is to coordinate a monthly birthday celebration. And to do that, he or she orders a cake, picks it up from the bakery, puts out some flyers, hey, happy birthday to Sally, happy birthday to Ted, sets up the break room with knives and forks and punch, and cleans up the break room after the party. So it's a little get together that the law firm has once a month to commemorate everyone who had a birthday that month. Well, Bob is the new receptionist, and he says, I can't participate in this because his religion does not believe in them. I believe Jehovah's Witnesses do not believe in celebrating birthdays. I could be mistaken about that, but that's what I think the faith is. Not that that's important. So, how can they work through that? Well, again, you'd want to have an iterative process with Bob to say, well, what part of this could you do? Well, as the receptionist, I'm guessing that Bob does from time to time set up sandwiches and um, drinks for other types of conferences that happen. And so it might be that Bob is able to put out the napkins and the forks and the plates and the punch. Um, but to require him to put out the birthday flyers and to pick up the cake is a step too far. And so you may want to work through which ones can you do, which ones can't you do, and then to have somebody else do those tasks. And it may be that while those other people are picking up the cake, Bob is performing that person's function. Maybe Bob also has typing skills, and so he can sit in at Teresa's station, Teresa's secretary, while Teresa runs to the bakery and picks up the cake, for example. So Farmersville Steel Fabricators hires Mahinder, a practicing Sikh, as a forklift driver. So OSHA rules require that all employees in the plant wear a hard hat. Again, that's a safety issue. Mahinder refuses to wear the hard hat because he's unwilling to cover his turban. Also, in many of these cases, that a hard hat won't fit over the turban. And if Mahinder is a Sikh, he may well have, because Sikhs usually do not cut their hair, he may have a great deal of hair that would need to be into a hard hat. And so, under those circumstances, the employer demotes him to another role that doesn't require that he wear a hard hat, perhaps in the front office. Mahinder says, well, that's discriminatory. I'm earning less pay. But under these circumstances, Farmersville Steel Fabricators will probably win if the demotion was the only alternative available that did not cause an undue hardship. And under these circumstances, it appears that that's a pretty reasonable course of action. And this has been litigated in other circumstances. So this is a pretty common resolution. Again, safety almost always trumps religious beliefs. So let's consider the Thomas case. This is a U.S. Supreme Court case. The issue is, did the state violate a worker's First Amendment rights by denying the worker unemployment benefits on the basis that the worker quit because of his religious beliefs? And the answer is yes. Now, before we dive into this too far, let's notice a few things. For example, we're looking at state action. The denial or granting of unemployment benefits is not the action of the employer, it's the action of that particular state. And so therefore, because it's state action, we are concerned about the First Amendment. So this is, even though Thomas was employed by a private company, his denial of unemployment benefits was a state of Indiana action. So this is a little bit different than your standard case. So in this case, Thomas is a Jehovah's Witness, and Jehovah's Witnesses are pacifists. They do not believe in participating in war actions or even being involved in armament preparation or creation. So anyway, his employer switched, I guess, businesses to some extent and got into the business exclusively of producing weapons for warfare. Well, Thomas was no longer able, according to his religious beliefs, to participate in his role. There weren't any other roles for him to have in the facility, so he left the employment. Now, from his perspective, he wasn't resigning because he had no choice. He wanted to be laid off, but the employer said, we have work for you. And Thomas said, but I can't do that work because of my religion. Well, Thomas then applied for unemployment benefits, but he was denied. And the state board said, well, there's work for you. The employer says you can come back tomorrow. But Thomas said, well, but the only work they have for me is work that would violate my conscience. And so the U.S. Supreme Court said that Thomas is not required to violate his conscience. And so therefore, Thomas had a right to the unemployment benefits. Now, keep in mind in this case, nobody was saying that the employer was wrong to not offer Thomas another job. All of the employer's jobs were in the armaments business now. And so therefore, it would have been an undue hardship for the employer to be required to continue to employ Thomas given the change in its business model. So there's no issue about the employer violating the law. You don't need to know the name of this case. Under Title VII, an employer is not required to resolve the conflict in the exact way that the employee wants. This is important to keep in mind. Let's consider this case, and we have another case too, also along these lines to talk about in a minute. So Mary joins a particular church. As a member, she now no longer is going to be wearing pants. She works at a restaurant, or I guess it's a restaurant, and there's a uniform, and all the employees wear these kind of coveralls to fit with, or maybe it's not a restaurant, maybe it's that they're actually preparing the seafood for shipment, and so they all wear these coveralls that are designed to be a safe work environment. Mary would wear the coveralls prior to joining this church, but now she says, I don't want to. So she explains to Bob, the owner, that this is against her religious beliefs to wear the coveralls because obviously coveralls are pants. So Bob and she brainstorm and come up with a solution. She'll be allowed to wear a skirt as long as she's wearing a protective jacket over the skirt, and she wears knee-high boots that will protect her legs from, I don't know, scales of the fish scratching her, or shark fins or something. Anyway, I don't know all the dangers of this particular industry. Mary says, well, yeah, okay, but those boots, they're not fashionable. I want to wear something that looks better than that. Well, again, not being fashionable isn't a religious issue. And so Bob can say, no, these are the boots you need to wear. They're safe. They're the safe boots. They're going to meet the needs that we have for you in being safe at work. And so Mary's objection to the boots isn't that they violate her religious beliefs, but that she doesn't like the way they look. So if Mary refuses to wear them, Bob would be perfectly within his rights to fire her for not wearing the designated outfit. Let's look at this scenario. So Mary has been a customer service associate for 10 years. She provides assistance to customers as they are in the store. Initially, she was a Methodist, but she has converted to Islam, and now she wants to wear a hijab to work. And the particular hijab she wants to wear is a full body cloak with a small mesh like screen where her eyes are, so she can see out a little bit, but no one can see her face, not even really her eyes. And her view is somewhat obstructed as well. Her employer says, well, look, let's look at our dress code. This doesn't fit with the dress code that we have. Oh, going back, by the way, let me just remind you here. Uh, Whenever you see safety as a reason for a particular policy, that's a really good argument for an employer to have. Safety, again, almost always trumps religion in an accommodation situation. So let's go back to Mary's scenario. Um, uh, so the employer says, look, we feel that you wearing a hijab on the sales floor would make you less effective because you wouldn't be able to see customers as clearly. Customers wouldn't be able to see your welcoming smile, indicating you are available and eager to help them. And uh, so it would undermine your customer service focus. So what the employer decides to do is to move her to a different department, and she would provide customer service support via telephone. Obviously, over the telephone, there would be no visual experience that the customer would have. Now, it's important to keep in mind that this is not an example of customer preference. It would be wrong for the employer to say, look, a lot of our employees don't like Muslims, and so we don't want you to look like a Muslim because our customers will be offended. That's not a valid reason. But it could be a valid reason to say one of your roles as a customer service person is to be welcoming. And part of the way you are welcoming is for the customers to see your smile, to see your eyes and your demeanor, and to see all those physical signs of welcome and openness to having a conversation. So in this situation, Mary refuses to take on this role. Under these circumstances, I'm going to say that the Allen department store is probably not going to be liable, especially if Mary did not receive a reduction in pay or hours. I think it's pretty reasonable to say that, when you're a customer service person, the customer ought to be able to see your face if he or she is shopping in the store. But let's say Mary were wearing a different type of covering. Let's say she was just covering her hair and was wearing a very modest outfit. And so the customer could still see her smiling face, her welcoming expression. Well, then I would say that Mary should be allowed to perform her duties with her hair covering. Now, let's say that Allen Department Store wants all of its employees to wear blue. That's kind of its signature color. Well, then it could require that Mary wear a blue headscarf and a blue outfit, but it wouldn't be able to insist that she wear a garment that was outside of her religious requirements unless there were safety issues, and there doesn't seem to be safety issues in this circumstance. This is the case similar to the one we were talking about here with the unfashionable boots. Let's talk about this one. This is a U.S. Supreme Court case in this area. And in this particular situation, the question is, must an employer accept the employee's proffered accommodation absent proof of undue hardship? And that is no. The employee should be advancing ideas, of course, but that doesn't mean that the employer has to take the ideas advanced by the employee. So in this situation, Mr. Philbrook was a teacher, and his particular um, or the particular benefits that were given to him by the school board was that he was entitled to 3 days of leave for religious holidays every year. But his particular religion required that he miss 6 school days to fulfill his religious obligations. So the first 3 were all taken care of because of this 3-day leave. The contract that his teachers group had with the school district was that sick days couldn't be used for religious observances. And so he was using 3 unpaid leaves. He was getting the time off, but his pay was being docked for those 3 days. Now, what Mr. Philbrook wanted to do is he wanted to use 3 of his sick days each year, which were paid, so that he would be kept whole. He would take his 3 religious holiday days, his 3 sick days, that would total up to his 6 days of religious observance. But the school board said, no, we aren't required to do that. We're going to follow the terms of the agreement. We're going to let him, Mr. Philbrook, use his unpaid days, not for the 3 unpaid days, and not 3 sick pay days. And the court agreed with him. The court said that the employer had met its obligation when it offered the reasonable accommodation he did. Obviously, it's not the one Mr. Philbrook wanted. Mr. Philbrook wanted to earn more money. Perfectly understandable, but it's not a religious requirement that Mr. Philbrook earn that money. There is no requirement that the employer follow the particular reasonable accommodation that the employee wanted. You do not need to know the name of this case. So now we have completed the prima facie case and the duty to reasonably accommodate. In our next presentation, we'll explore the upper limits of the duty to reasonably accommodate, specifically undue hardships, as well as other topics in religious discrimination law. Thank you for your attention. As always, if you have questions, please pop into my office hours. I would be delighted to talk to you in more detail on this topic. Thanks again, and have a wonderful day.